Good afternoon, everyone, and welcome to the Gain Center. We are excited to present this webinar to you all, talking about 6 guidelines for providing assisted outpatient treatment to justice-involved clients. I'm Melissa Neal. I'm a Senior Research Associate at Policy Research Associates, and I'm also the lead for communications for SAMHSA's Gain Center. And all of us who are presenting today have involvement providing technical assistance to local sites implementing AOT programs. And so one of the issues that that many jurisdictions have grappled with is helping clients navigate when they can enter AOT programming or if they are already in AOT programs, how to handle the situation when they become involved with the criminal justice system. And so we hope that this webinar will be really helpful, providing assistance and some thoughts for you to consider as you help your programs really shape policies and procedures around how to handle this issue. And we do want to make clear that the views, opinions, and content expressed in this presentation do not necessarily reflect the views, opinions, or policies of the Substance Abuse and Mental Health Services Administration or the U.S. Department of Health and Human Services. Just a couple of housekeeping items. Throughout the presentations, we welcome questions, and you will see on the side of the panel a Q&A pod. There, feel free to enter as many questions as you would like throughout the presentations, and at the end of this the webinar, we will cover all of the questions. We also have a couple of polls. One is already, a couple are already live. We would love for you to comment on where you are located in terms of a rural or suburban or urban location. And we also would like to understand what kind of organization you're representing as you join us today. And finally, just note that this webinar is being recorded. So we've got a great agenda for you today. And as I mentioned before, we have 2 presenters, Dr. Lisa Callahan and Brian Fetton, who have worked closely with jurisdictions all across the nation in shaping their AOT programs. And so we're really excited to have them share with you today about navigating when clients are involved with the criminal justice system. But first, I'd like to turn it over to Miriam Chase with some comments that she would like to provide as she represents SAMHSA.
Thank you, Melissa. Hello, my name is Miriam Chase. I am the Lead Government Project Officer for Assisted Outpatient Treatment Program, for short called AOT, on behalf of SAMHSA and the Center for Mental Health Services. I welcome you and thank you for your participation. AOT for individual with serious mental illness or SMI was authorized by the Protecting Access to Medicare Act of 2014, Section 224. Within the Act, AOT described as medically prescribed mental health treatment services that an individual with SMI receives while living in a community under the terms of a law authorizing state or local court to order such treatment. As you may know, many people are arrested or routed into justice system when community-based mental health services are not available, or when law enforcement or first responders do not have working relationship with these services. A range of statistics showed that people with mental illness are more likely than general public to be involved in the criminal justice system. A 2016 analysis of National Survey on Drug Use and Health data shows that more than 30% of individuals with SMI have a lifetime history of arrest, compared with 20% of people without SMI. The Bureau of Justice Statistics also report that 44% of jail inmates have been told by a mental health professional that they had mental disorder. Furthermore, prisoners with more than one arrest are more likely to have symptoms of mental illness than prisoners with just one arrest. The use of AOT has expanded as communities seek to reduce inpatient hospitalization and provide community-based treatment and services to people with SMI. While AOT is civil commitment into outpatient treatment, many clients meeting the eligibility criteria for AOT are also involved in the criminal justice system. This can result in confusion between the roles of civil and criminal courts for systems and individuals participating in AOT programs. This webinar is intended to provide additional guidance and clarification around working with AOT clients who are involved in the criminal justice system. The following guidelines from experts in the field can help local systems differentiate between the civil and criminal justice system. I hope this information will be helpful to you, and I look forward to hearing your questions. Now I'll turn it over to Melissa.
Thank you, Miriam. And just
Melissa?
briefly, thank you, Miriam. Now I'm going to briefly introduce our panelists. First, we have Dr. Lisa Callahan, who is a Senior Research Associate at Policy Research Associates, and she provides many of our trauma trainings. So some of you may have met her through some of the trauma trainings or trauma train the trainers that we conduct across the nation. She works on many SAMHSA projects and currently and in the past, including competencies to stand trial, best practices in medication-assisted treatment, best practices for psychiatrists working with justice-involved people in community care, treatment court collaboratives, and she was one of our senior consultants providing technical assistance to SAMHSA's assisted outpatient treatment grantees in the past couple years. Next slide. And Brian Stetton is with the Treatment Advocacy Center, and he also has extensive experience working with jurisdictions across the nation, helping draft and shape AOT law and legislation, as well as helping shape what those AOT programs might look like once legislation is passed and the communities are ready to implement. So now we're going to turn it over to Lisa to start our presentation.
Thank you, Melissa. Good afternoon, everybody. I'm really pleased to be able to talk with you today. I'm going to provide a context for the guidelines that Brian and I are going to later speak about in terms of allowing justice-involved individuals to be eligible for your AOT program. So first of all, I want to just make sure that we're all agreeing on what AOT is. And in the short version, it's outpatient commitment. It allows an interested party to petition local courts to order a person with a serious mental illness to enter and remain in community-based treatment. Most AOT orders are for a specific length of time set by statute. Sometimes statutes allow for a range of period of time, and AOT is intended to facilitate community-based behavioral health treatment to individuals by use of the court order. Now, there are, most states in the United States have AOT laws. Not all of them have implemented them, and a number of them have SAMHSA grants, which are helping facilitate the implementation of AOT. But I think it's still true to assume that there are as many ways of implementing AOT as there are states that have AOT statutes, and even a lot of variation within each state. AOT laws typically require individualized treatment plans, and that really is a focus and a strength of AOT. And while a lot of different treatment services might be included in that treatment plan, most include case management, medications, and other specific therapies such as cognitive behavioral therapies. People who have an AOT order are supervised by the treatment provider and with varying degree of oversight by the court. And that is something which is specifically is a focus of AOT, is that it is a treatment-based program that is implemented through the civil court, not through the criminal courts. Some jurisdictions, but not all, require periodic face-to-face hearings before a judge, the judge who has signed the commitment order. and this is to help monitor the adherence to the court-ordered treatment. Some jurisdictions require an appearance before the judge only if there's an issue such as noncompliance or if someone needs to have their treatment orders reviewed. There is wide variation, not just across states, but even within states as to the extent that judges are having these types of hearings for AOT. There are some similarities, but very broad similarities across the AOT statutes. The primary common characteristic is that they all require a serious mental illness to be demonstrated through a clinical evaluation, and typically they also require there be some evidence of risk of harm to self or others. Some states allow, in fact, most states allow for grave disability and risk of relapse to be included as well, and typically the states require that there be a documented history of noncompliance with treatment and that treatment would be beneficial. AOT can be implemented in a number of different ways. Most commonly, people are probably familiar with AOT as what we would call a step-down program from psychiatric hospitalization, where someone is discharged from the hospital and placed on AOT orders so that their treatment and adherence to treatment will continue to be monitored, but in this case in the community. Sometimes it's used as a means of engaging clients who are in the community and remain in the community but are not engaged in treatment, so a way of encouraging them and the provider to provide services, evidence-based services. And also, some may also use it as a way of kind of keeping an eye on people who they have some concerns about as they're being a danger to themselves or others. All of these mechanisms are used to some degree or another, and most states allow, at least statutorily, for AOT to be implemented in a multiple number of ways. Now, the context for this, this webinar is really to think about AOT as part of the larger diversion from the criminal justice system, that is, diverting people with serious mental illness and co-occurring disorders away from the justice system when that is at all possible. So for AOT to be part of early diversion, there are a number of conditions really that need to be in place. Probably most importantly, for AOT to be considered part of early diversion, there has to be cross-systems collaboration. Primarily, we think about that as being between behavioral health, community behavioral health, and the justice system. For example, if someone has charges that are pending, the prosecutor, the defender, the judge all need to be on board in terms of dismissing charges, and Brian's going to talk a little bit more about that later, or transferring jurisdiction, if you will, in sort of a layperson's terms, to the probate court or to the civil court that deals with civil commitments. At that point, the criminal court really has released that individual to the civil court and doesn't have any more responsibilities for them. And as you can imagine, and I know some of you are probably struggling with this in your community, sometimes the criminal justice officials don't really want to release someone, their responsibility for that person, depending upon the charges. But it's really important in order for AOT to be part of diversion that there is this cross-systems collaboration and really a developing of the trust that behavioral health and the justice system and the civil system can work together. There also are some legal and practical avenues that must be in place for an individual who's facing charges, criminal charges, to be diverted out. And this may seem like an obvious requirement, but it's one that really can't be can't be overemphasized, and that the treatment resources have to be available in the community. It really is of no service whatsoever to the community to have an AOT law if there aren't the requisite evidence-based treatment services available for individuals in the community. So those really need to be in place before you can even consider effective implementation of AOT. And as I said, the communication across the systems is also really critical. The cross-system collaboration really doesn't end just with behavioral health and criminal justice. because part of AOT is a much broader wraparound treatment approach, as I said, this individualized case management. So in order for AOT to be successfully implemented, there also needs to be community support through housing providers, social service agencies, family advocacy groups, and peer support groups. All of these community stakeholders are really critical to the success of an AOT program, especially when you are considering taking into an AOT program people who have justice involvement. Pre-arrest diversion requires communication and education and training between the treatment professionals and the police. In communities that have CIT programs or LEAD programs, you probably already have the infrastructure in place to have those conversations. They've had training around issues dealing with persons with mental illness, so you already have really the infrastructure in place to begin to talk about AOT as a form of pre-arrest diversion. But the police have to know that when they encounter someone who they believe have a serious mental illness, that there's a way to steer them into treatment and out of the justice system and away from justice involvement. So the police are obviously among the really critical players here, stakeholders here, for any kind of early pre-arrest diversion as part of your overall criminal justice diversion. In terms of early jail diversion, this requires that your sheriff or jail administrator, if the sheriff doesn't run your jail, to know about AOT, to have procedures and policies in place to know who is eligible, to have screening and assessment for suitability available as early as possible when someone is booked into the jail, and to know who to contact if AOT might be an option. So having a really strong relationship with the police and the sheriff is really critical if you want AOT to be implemented as a form of early diversion and to get someone out of jail, out of any kind of custodial care and into treatment without spending too many days, avoiding jail stays altogether, and certainly not spending many days there. So many of you are familiar with the sequential intercept model, and we are strong advocates that this is a very good framework for many types of justice reform, but in this case talking about AOT. For AOT to be part of the criminal justice diversion options in a community, officials are really encouraged to consider each intercept and determine which behavioral health and criminal justice professionals work within each intercept and plan what education and training is necessary when you implement AOT and make it available for people who are justice involved. And it's not just, even if you're focusing on intercept 0 and you're focusing on early pre-arrest diversion, most people who you're going to come into contact with, and some of the statistics that Miriam cited, they've had experiences in all 5 of these intercepts in many cases. And they are known to both providers and justice professionals all along these 6 intercepts. So it's important not to just focus on the one intercept where you may be, but instead think about it across all 6 intercepts. By intentionally thinking of who is in each of these intercepts, who the professionals are, it also gives you an opportunity to know what resources might already be in place. So in thinking about AOT as a possibility for people on probation or someone who is reentering the community after a period of incarceration, whether it be jail or prison, it's important to know across the criminal justice system what resources, behavioral health resources, are already in place and who those key partners would be. That it isn't just looking, as I said, not just at the part of the system that you're involved in or that you're familiar with, but really intentionally think about this across the whole model. By examining every intercept and by identifying key officials, this way you can get everyone's input, including input from peers and family members, and it becomes clear what resources already exist and where the gaps are. So we would strongly encourage you, as you begin to think about accepting people with justice involvement into your AOT program, to put the SIM in front of you and start thinking about all the different partners and stakeholders you already have and the resources you already have in your community. Next, we are going to discuss the 6 guidelines for providing AOT to justice-involved clients. And guidelines 1 and 2 are really speak to the fact that people should not be automatically disqualified from AOT simply because they have criminal justice involvement. Guideline 1 is here on the screen. Someone with pending charges should not be disqualified. It should not disqualify someone from being referred to AOT. Later, they may find that they're not suitable for AOT for any number of reasons. There may be statutory problems. There may not be the treatment and supervision that's necessary. But it shouldn't be an automatic disqualification simply because someone has pending charges. The second guideline speaks to people who are participating in community correction. That also should not disqualify someone from being referred to AOT. If someone is on probation or parole, that we're suggesting that should not on its face be a reason to disqualify someone from AOT eligibility, or at least being considered for AOT. Sometimes they have multiple charges, multiple cases that are open, some are closed, they're on probation for one and they have charges pending on another. So AOT might be exactly the kind of effective intervention that will help someone in their recovery. As noted above, having a comprehensive plan of how someone with justice involvement can be assessed legally and clinically for AOT should remain an option rather than simply disqualifying anyone who has pending charges or who is on probation or parole. Next, Brian Stetton from Treatment Advocacy Center is going to discuss guidelines 4 through 6.
Okay. Thank you so much, Lisa. And I just want to echo Lisa in thanking everyone for joining this webinar. I'm thrilled that we have so many people interested in what I consider really to be the next frontier in a movement that I've been part of for 20 years now to make AOT a routine tool in the toolkit for every mental health system in America. And, I think it's a real testament to the progress we've achieved just really mostly in these last few years that we can have discussions like this where we can really kind of zoom past the threshold questions like what is AOT, why do we need it in the first place, and really get to the next level that we're on today, which is to explore how can we make our AOT programs better? How do we ensure we are finding all the people who need this sort of intervention to facilitate their recovery from severe mental illness? And my hope is that there are lots of people on the call today who are working in currently functioning existing AOT programs who see this, as I suggest, as the next level on how we make these programs optimal. To me, one of the best answers to that question is the topic of this webinar, because I know from my travels visiting AOT programs around the country that there is enormous untapped potential for AOT to help people with severe mental illness who are trapped in the criminal justice system. So I'm going to use my time here today to kind of walk through some of the legal and procedural aspects of how I believe that can work. And, it's not a lot of that that's really happening right now. As much success as we're having with achieving great results with AOT programs, they are mostly serving people who are coming out of hospitals. This is where I think we go from here. So to me, an important starting point for this discussion is just to make sure everyone is crystal clear on the distinctions between the related but often confused concepts of mental health court and assisted outpatient treatment, or AOT. And, these are terms that are often used interchangeably. It's unfortunately common after I make a pitch to folks that they need AOT in their community for me to be told, oh, we've already got that. We just call it mental health court. And what they usually mean by that, when I press them a little bit, is that they have a diversionary criminal court for mentally ill offenders, which is wonderful, and it's yet another essential tool in the toolkit, but it isn't AOT. So let's kind of dive into the differences and square that away. Mental health courts are criminal courts, right? They are where charges for a crime that's been committed that are currently pending are held in abeyance while the defendant receives community-based treatment. To qualify to be served by a mental health court and receive help from them, you must obviously first be charged with a crime that falls within the type of offense that jurisdiction allows to be diverted to mental health court. And basically the deal between the criminal justice system and the offender is, if you follow this treatment plan and do everything we ask of you, when you come back to court at the end of this period, the charge will be dismissed. And you won't have that on your record, and you will not have had to have served time for that offense. And, as a practical matter, that basically means that mental health court really works only with someone who is competent to stand trial, because, if someone is not competent, there is no potential that they would face those charges without having competency restored to begin with. So generally, mental health court is for people who are facing viable criminal charges because they are competent to stand trial, and this is an opportunity for them to be diverted from the criminal justice system. And it is, at the end of the day, a purely voluntary program, right? Because the person is being given a choice. They could, if they so opted, face the music, right, to roll the dice and see if they can, beat those criminal charges and not have to take part in this program at all, and, potentially even be acquitted and not have to have served time or faced charges. So, that is a choice that the person is making to be in the mental health court, which is, one you would expect most to make. Now, AOT courts, by contrast, they are civil courts. They are not criminal. One does not have to commit a crime as the price of admission to be there in the first place. And they work with kind of a different incentive structure. Unlike mental health court, because AOT is not relying on the fact that the person has committed a crime first, there is not this hope of avoiding punishment for that crime that is motivating the person's engagement with treatment. Instead, the person's qualification for AOT is based on civil commitment criteria, and we'll get into that in a little bit later in more detail. And that's not to say that many of those folks won't also have a criminal justice history. It just simply means they are not at this moment facing a criminal charge, but of course many people with severe mental illness fall into the criminal justice system when they're not engaged with treatment in the community. They commit acts that lead them to develop criminal records. So it's not that we're necessarily talking about a very different population. It's just we're really talking about a difference in where the person is at this particular moment that we are trying to get them some help. AOT court, because it does not rely on that incentive of the person wanting to have their charge go away, is really much more reliant on the kind of motivational power of the judge, what we call the black robe effect. In most states, it's actually taken off the table that the judge can even hold the person in contempt of court for failing to obey the court order. There are some states that allow that technically, but it's strongly discouraged everywhere that we work with programs to establish AOT programs. It's not at all about the teeth of what the court might potentially do to you. It is really just about a person feeling the love from the courts, getting a sense that the judge cares about them, would walk through walls to make sure they get the services they need and everything that is going to make it possible for them to live the life they choose, and being inspired by that and motivated by that. But the other side of that coin is that AOT courts at the end of the day are not voluntary. Which isn't to say that everyone who participates in AOT is there under a court order. There are many people who like the idea from the, it's used as discharge planning from a hospital. People more often than not tend to embrace the opportunity to participate in AOT, and so they are signing, in most cases, voluntary settlement agreements rather than being placed under formal court order, but they are still placing themselves under the observation, the supervision of the court. And the decision to sign that voluntary settlement agreement is made with an understanding that if they don't make that choice, that the system has the authority to then go ahead and file a petition and put them under a court order through an involuntary process. So the understanding is conveyed that one way or another this is a program that the system has determined is in your interest and would like you to be a part of. So that's very different than mental health court. The takeaway here, I think, in terms of why I want these concepts to be understood as distinct, is that if we are in fact looking to bring people who are currently in the criminal justice system over to a civil court to receive AOT, there is a kind of danger of blurring these lines, of asking AOT courts to kind of code switch from one client to another and function as mental health courts with certain clients and function differently with others. And I think that's something really to be avoided. And most of these guidelines I'm going to flip through now are really designed with that in mind, the idea that we want to ensure that your efforts to make AOT available as a lifeline to people who are trapped in the criminal justice system do not lead to a mission creep within your AOT court, where you are bending the AOT model into the shape of a mental health court. And again, that's in no means a knock on mental health court, which I also think has a very important place in the firmament here. So the first line of defense, I think, to ensure that your AOT program stays true to its function is to insist that AOT is imposed only in cases where the person qualifies for it under the existing civil criteria. So, typically in a mental health court, we are not insisting that so many findings have been made about the person's clinical condition, right? We basically have determined this person has a mental illness, they have committed a qualifying offense, and the DA and all sides are convinced that if this individual engages with mental health treatment, he or she will not pose a threat to the community, and so it makes all the sense in the world to try this mental health court as an alternative to prosecution. But with AOT, it's a lot more complicated because we have specific laws on the books that say what it takes to qualify for AOT, what it means to be eligible. And in some states, that's a unified form of civil commitment criteria. That is, there is one way in which the state will define what it means to be civilly committable, generally that you are dangerous to yourself or others, and then it is for a judge to determine what is the least restrictive appropriate alternative to address that person's current dangerousness, and that might be a hospital or it might be the community if the person is dangerous to themselves or others but not necessarily in need of hospitalization at that moment. There are other states that have separate tests for civil commitment for inpatient care and outpatient care, and that I think Lisa alluded to this a little bit, that there are many states where to qualify for AOT you must have been found to have had a certain number of hospitalizations or a certain number of violent episodes over a period of time, 2 or 3 years, that are directly related to your demonstrated inability to adhere to treatment in the community on a voluntary basis. So if you've identified someone in the criminal justice system as a potential candidate for AOT, the process must start with a clinical determination of whether this person actually qualifies for AOT under those statutory criteria that you would not have to worry about if you were using a mental health court. And you make those clinical determinations generally by examining the person, having the person submit to an exam by a clinician. And, of course, there may also be a need to do some investigation of the person's treatment history if your state law requires that certain history of non-engagement with treatment in the community. And, of course, the next part of it is that process leads to the need to actually file a petition, right, where you must actually bring this matter formally to civil court. And in most states, it's the probate court that hears matters of civil commitment. But, that's got to be followed whether this person is coming from the criminal justice system or not. So really the first part of making sure that you respect these lines is to develop this process where people coming from criminal justice are coming in the exact same way and for the exact same reasons that others would be who were coming from a hospital or from the community. Okay. Flip ahead here. So the next guideline here is about the importance of keeping AOT open to those who are not criminally justice involved. And this guideline is really addressed directly to the many AOT programs that are already struggling to keep up with the demand for their services within their own communities. And I say that not because AOT programs should ever really be very large. Quite the contrary, a point we often stress about AOT is that it's not intended or designed to serve the needs of people with severe mental illness in general. Nearly everyone with severe mental illness does require treatment services within the community to maintain recovery, but the great majority do not need for that to take place under court supervision. So to just kind of put some numbers around that, if you look at New York City as one of the more robust AOT programs that we have in the country, is probably doing about as much AOT as you will find anywhere. That's a city of 8 million people. So if you take the statistic that 4% of a population has severe mental illness, that suggests there are about 300,000 people in New York City with severe mental illness, and at any given time they've got about 1,500 people under AOT orders. So that's half of 1% of all the people with severe mental illness. And, that I think that makes clear that we are really talking about an intervention that is intended for a small subset, that is, folks who have really demonstrated by their history a great difficulty engaging with community-based treatment on a voluntary basis. But, even with that being the case, that this is by design a small-scale program, we know that there are many AOT programs across the country today that are underfunded, under-resourced, too small to serve even the entire population of folks within their communities who meet these criteria. And so there is this very unfortunate need we see in many AOT programs to triage. As much as they would like to serve everyone who stands to benefit from their services, they make hard choices every day about who seems to need those services the most. And that kind of AOT program, I think, should proceed very carefully in opening their doors to this new avenue of participant referral that we're talking about today. Because there is a possibility that folks working on the criminal justice side, once the kind of word gets out that this is an option now, are going to be very eager to make these referrals in cases where AOT seems to them to be the best solution. And that could really ramp up the challenge of your demand exceeding your supply of slots in your AOT program. So the remedy here I'm suggesting is not that if your program is small or still in kind of a pilot phase, you want to close your doors to criminally involved clients as a matter of policy, because there's no question that you are going to find some of the people who you really most need to serve are going to be currently trapped in the criminal justice system. But I do think it's important to resist any pressure to make criminal justice involvement a prioritizing factor, something that puts the candidate at the front of the line, because the effect of that could easily come to distort the mission of your AOT program and lead to a denial of access to folks who really do need AOT desperately but happen not to be in that criminally justice involved box right now. And, of course, that would undo one of the great things about AOT, which is that you don't have to commit a crime to get help. So the point here is to really keep the focus on making your decisions on how to fill those slots purely on clinical factors. The next guideline is kind of a biggie. So, look, if you're going to be bringing folks over from the criminal justice side to a civil AOT court, obviously that is not going to happen unless the prosecuting agency that's prosecuting those current charges against the person is on board with it. And the prosecutor is really in the driver's seat in determining this near future fate of this individual, at least up until the day when that filed charge must either be prosecuted at trial or dismissed. And as a general matter, and for very good reasons, a prosecuting agency tends to be reluctant to surrender its leverage against an individual who they believe has committed a criminal act. So, not surprisingly, if you go to a prosecutor and say, hey, let us take this case off your hands and we'll deal with it in our court over here, and we'll see if we can motivate him to engage with treatment, the natural reaction of that prosecutor is going to be, okay, well, we can try that, but, I want to hold those charges in abeyance so that if it doesn't work out on your side, I still have some recourse to protect public safety, and, also maybe the offender's knowledge that the fate of these charges kind of hangs in the balance of how they do in the AOT court. That might actually motivate the person to stay on their treatment plan. And, if you were to allow your transfer to AOT to work that way, you would essentially be turning your AOT court into a mental health court. And again, I have no problem at all. Quite the contrary. I'm quite a big fan of mental health court conceptually. But I just think it's a mistake to kind of cross the wires of the two models in that way. And, for one thing, I don't really see what value AOT would add to that equation over a mental health court. it really would only kind of complicate the matter by adding another kind of court to the way you're addressing the person's needs. So, if you have a situation where it is viable to put the charges aside while you pursue community treatment, to me it just makes much more sense to do that within the framework of a mental health court. And if the problem is that you don't have a mental health court, or your mental health court doesn't have the good treatment resources attached to it that AOT does, my advice would be to work on that rather than attempt to kind of dance awkwardly between the two courts. So, where does that leave us then on the question of how to use AOT to rescue people who just need treatment, not punishment, but are trapped in the criminal justice system due to pending charges? Well, I think there is a group of folks that we can extricate from that situation, but to me it's not the ones with the viable pending charges. To the extent possible, we should try and help them in mental health court. To me, it's the folks who are trapped in what I call competency restoration limbo, right? So it's extremely common for people with severe mental illness who are charged with crimes to never face prosecution on those charges because they are determined initially to be incompetent, and they don't get restored to competency before their statutory time limit runs out. So what happens to those folks now? They basically languish in a jail cell or a forensic hospital while the competency clock runs out. And then at the end of that period, the charges get dismissed, and the person goes out into the community still without the kind of support that, had they received it in the first place, likely would have prevented their offense and prevented the wasted months of their lives and all the staggering expense associated with that. So, we're setting people up to fail again. It's just insanity. And here is where I think that AOT can make a really meaningful impact. And, the prosecutors I've spoken to about this tell me that there are cases that from the beginning, it's kind of obvious that competent restoration is unlikely to happen in the next, 90 days or however long the law allows them to try it. So from a prosecutor's point of view, if you've got a defendant where the most likely outcome is 90 days of sitting in competency restoration followed by a dismissal of the case, and this person also happens to qualify for AOT based on their clinical needs, wouldn't it be more appealing to say, let's agree to dismiss the charges now with the understanding that this case will go straight to the civil court for an AOT proceeding, meaning that this defendant will receive not only a robust community treatment plan, but also the kind of oversight that a judge provides and a rapid response to any appearance that the person is beginning to falter in their engagement with treatment? I really think so, and I think this is the most obvious place for AOT programs and criminal prosecutors to come together and use AOT as a means to solve this problem that has really been dumped unfairly in the lap of the criminal justice system and kind of allocate our resources in the right direction. That's going to require the development of some protocols and some procedures where there can be real trust between the two sides of the system that the dismissal of those charges is inevitably going to lead, because of an agreement that's been reached beforehand, to a petition for the person to participate in AOT. And I just want to give you a demonstration of what I think this can look like in law. It was just shown to me last week. This is a rule that's about to go into effect in New Mexico, Supreme Court rule that's been promulgated effective February 1, where they have actually added language to the rule that guides how dismissal after a period of attempt to restore competency has ended and failed. So if you look at this rule, it talks about proceedings after a finding of incompetency, and it says that if the incompetent defendant has not been charged with a felony, the following provisions should apply. If the case was originally filed in district court, the court may dismiss the case without prejudice in the interest of justice. Upon dismissal, and this was in the rule before, it says upon dismissal, the court may advise the DA to consider initiating proceedings to have the person committed as an inpatient, right? If the person is also, in addition to being incompetent to stand trial, is considered dangerous to themselves or others to the point that they meet inpatient civil criteria, there was already a rule that said you should, let the authorities know that maybe that's where we should go from here. But now they're adding language that says that in the alternative, the court may advise the attorneys in the matter to consider referral to an appropriate person authorized to petition for AOT. So, for the many people who cannot be restored to competency but do not meet criteria for inpatient commitment, AOT now becomes a viable option, so long, of course, that they meet the ordinary criteria for that. The last guideline we'd like to bring to your attention is just this, the importance of the counsel for the participant in this program to fully make the legal implications of this transfer from one court to another clear to the person who is going to experience it. So there are basically two attorneys who have roles here. There is the criminal defense attorney who's representing the person on their pending criminal charge. If in fact we're going to be dismissing without prejudice, it's important that the person understand that that doesn't mean that they necessarily won't ever be prosecuted for that crime. It still leaves the prosecuting agency with the authority to refile those charges at some point in the future, which I think they would be unlikely to do as long as things go well. And, of course, refiling would still leave open the question of the fact that the person has not yet been found competent to stand trial. But nonetheless, the person should understand that there is a potential that they could be charged with that same crime again at some point in the future. But once the person comes over to the AOT side, I think it's really incumbent upon the attorney representing them there, because, of course, they have a full right to counsel for their civil commitment, as they would for whether that's inpatient or outpatient. It's important for that, because we want this person to not be scared, not be worried about the fact that they are now in AOT, to view this as quite rightly as something that is has been imposed because the court believes it's going to help them. We want this person to understand that not complying with the court order will not lead directly to the prosecutor refiling those charges, right? We want to have that level of comfort and trust that I think are essential to making AOT work well. And, of course, that would be accurate information because I think as a practical matter, the refiling of charges is probably something that would only happen at some point in the future if the person were charged with another offense. Those old charges might be brought back at that point and added to that subsequent prosecution. But it's not ever going to be a situation where, we punish you for not succeeding in AOT by having your charges refiled. And, of course, these are points that the AOT judge should really reinforce when he or she sees the person in court, to make sure there is an understanding of how this is all going to work and that the person is not worried about it. So those are the guidelines we have to present to you today. I thank you very much for listening, and we're, of course, happy to answer your questions.
All right. Thank you so much, Brian. So now we are going to look at the questions that have been submitted. And we also have a poll that has opened, and welcome your participation if you would like to have input into some future webinars that the Gain Center will produce later this year. And so just moving on to the Q&A. So continuing on the theme of criminal justice and AOT involvement, Brian, you mentioned that AOT is just one tool in the toolkit, or just one resource that should be available across the continuum of mental health services that should be in a community and available to people with mental illness. So both Brian and Lisa, would you like to elaborate more on the distinction between AOT and mental health court and why we try to make sure that those are considered separate?
I don't know what more I can say on that than what I did, because I think I kind of spilled my guts on that, because I do think that it's important that distinction be understood. But if there's anything you think I missed, Lisa, please feel free to add.
No, I I agree with what you said, and one thing I think I would add, and I know this has come up in some of the AOT communities that we've worked with, is usually in many states there are statutory exclusions in terms of charges for treatment courts, whether they be drug courts or mental health courts. It may be because they have justice funding and those have particular requirements. If they have SAMHSA funding, those don't have statutory limitations, just as an aside. And sometimes it's written into the state statute. So there may be, for example, there can be no violent charges for anyone in a treatment court. That also includes, not to minimize, please don't think I'm minimizing it, but that also would include any kind of domestic violence, which we know there are many issues. One of the reasons that NAMI is very supportive of AOT is because there's an awful lot of sometimes difficulty with managing family members who have serious mental illness. So I think that sometimes there's just they're excluded from even being able to participate in mental health court. And the other, I think, and Brian mentioned this in passing, is most counties don't have mental health courts anyway. So it's not an available option for people with serious mental illness. So in practical terms, if a state has an AOT law that's, at least in theory, available in each of the county, in each of the jurisdictions, most counties in the United States don't have mental health courts. So it's not even really anything that is not an either or.
Lisa, is it different in that the lack of a program means there's less of an opportunity to actually establish a program? I mean, as we've already said, the fact that we have AOT laws everywhere certainly doesn't mean we have AOT programs everywhere, far from it. And I actually think the mental health court model has pervaded the country to a greater extent than AOT has. But, if there is a need for a mental health court somewhere, would there need to be some kind of legislation that would empower that jurisdiction to start a mental health court?
There are some states that have no mental health courts, that have lots of mental health services available, such as the state of New Jersey, the state of Connecticut. They don't have mental health courts. So it's not necessarily that there aren't mental health services available, although that is the case in some specific counties and states that may have mental health courts. For sure, they're more likely to be in highly urbanized areas where there tend to be more mental health services available and, just the critical mass of justice and behavioral health professionals to start a program. Most mental health courts there are some states that are exceptions to this, but most mental health courts, certainly early on, were started on a wing and a prayer, and a lot of volunteer time from judges and others, because they felt strongly that it was a need that wasn't filled in their county. Some states fund mental health courts without, to the same extent they do drug courts. So it really varies greatly, but there, in the more rural areas where we know there are scarcity of resources, mental health resources and other health resources, it would be very difficult to have a mental health court.
Yep.
All right. So we've got a couple more questions. One person asked, if someone is referred to AOT but already has formal probation with mental health terms in their terms and conditions, what, if any, would be the benefit of AOT? And I'll just leave that to both of you to respond.
Yeah, no, it's a great question. I mean, one benefit of it might be that it would actually ensure access to quality services the person needs, right? Because AOT is not just, it's a mutual commitment. It's not just about committing the person to the system. It's also about committing the system to the person. So, one thing that occurs to me is it might make a person have a whole lot easier time fulfilling the terms of their probation or parole, if in fact we can get them into an AOT program that makes those kinds of intensive services available to them that might not otherwise be. But, the incentive on the person to engage with treatment, I think it's true, it really would come entirely from their probation or parole, because, unlike AOT, you've really got some serious teeth there when you can say to the person, you are at risk of going back to jail if you don't obey this probation term. So to me, the value of adding AOT to that equation would really be much more in terms of making the services available to the person. And it's unfortunate that it should ever have to come down to that. But, you know, that's the reality of our dysfunctional mental health system in a lot of places.
Anything you want to add to that?
No, I think Brian covered that well.
Okay, great. And so in talking about the enforcement of the court order, can you speak a bit about the enforcement of the AOT order, especially in cases of noncompliance with treatment?
Sure. So, you know, there's a little bit of smoke and mirrors involved in how we motivate people to comply with AOT. The reality is, if you look at the actual power of a court to respond to a person's failure to comply with the treatment that's been court ordered, it really doesn't go very far, if at all, beyond from state to state. The powers that you would ordinarily have over someone who appears to be disengaged from treatment and you know, may have come to meet criteria for inpatient commitment. At the end of the day, you can't punish somebody for violating the court order by forcibly administering medication to them or by committing them to a hospital simply because they haven't done what they promised the court that they would do. Those kind of deprivations of liberty are subject to very stringent existing legal standards, and appropriately so. You know, to forcibly medicate somebody, to strap them down and administer meds, and that's something that really is meant to take place in a hospital setting and only after it's been determined that the person lacks capacity to make their own treatment decisions. You can't be interfering with those important constitutional guarantees simply because you have someone under AOT and you really want them to do what the court has ordered. So what it really comes down to at the end of the day is that AOT generally makes it a little bit easier. It facilitates the process of having somebody brought in for an evaluation to determine whether it is now necessary to take a more severe action and convert the court order to one for inpatient care. And that evaluation may find the person doesn't actually meet standards for inpatient commitment yet, and so that person has a right to be released right back into the community. But ideally, what you're going to do is you're going to follow that experience up with a court hearing where the person is kind of reconnected with the treatment team and reminded of the fact that the court is taking this seriously and you know, is going to at least respond with a little bit of power it has to keep an eye on the individual and not wait until they act out in some dramatic way in the community before we, you know, respond with the evaluation that they may need. So it makes the system a little bit more proactive, but at the end of the day, what's really motivating the person to comply in the programs that, you know, we've studied is much more the fact that they don't want to let the judge down because they have developed a bond with that judge than it is the fear of what's going to happen to them if they do let the judge down.
Lisa, do you have any response to that?
No, I think Brian did a fine job covering that.
Okay. So one responder asked, so they have individuals who are participating in AOT and then are incurring charges. So what can they do? Do you have any guidelines in terms of steps that jurisdictions can take to ensure they're able to keep their AOT participants out of jail after being arrested on a warrant?
You want to try that one, Lisa?
No, I was thinking, that sounds like a lawyer question.
Yeah, could you? I'm sorry, Melissa. Could you explain the situation to me a little bit again? So,
I'll read the question verbatim. How do we help people who are currently in AOT who also have pending criminal charges? How do we keep them out of jail after being arrested on a warrant?
You know, I don't know that there's any real formula there other than that you want to, you know, have lines of communication open so that the prosecutors who have authority over those charges understand the nature of the person's illness, the fact that, you know, if they engage with treatment, they will most likely not pose a danger to the public, and to, ask for as much as possible for that to be taken into account when decisions are made on that criminal case. And, I don't know if you can do much more beyond that than just make sure that everybody within your criminal justice system understands AOT, what it's trying to accomplish, has compassion for the people who are taking part in it, and, takes into account a person's AOT status when decisions are made on criminal cases. And obviously, the more violent the offense may be, the harder that's going to be for the prosecutor and the less leeway they're going to feel they have. But, the other part of that I would, ask to have folks keep in mind is that where you have CIT, right, when you're the kind of first line of the law enforcement system are officers who are trained in mental health and understand the nature of mental illness. I think it's really important that the CIT officers within your police department are aware of who in the community is under AOT court orders, so that anything they may observe, they will bring that to the attention of the AOT treatment team, so that appropriate action can be taken before that person, winds up under arrest.
And just along those lines, another person asked, how is the handoff managed between a person in jail who has been put on AOT and the community-based AOT program? So in other words, does someone from the AOT program come to the jail and explain to the person how the AOT program works? So I guess that's a question about potentially letting people know in jail that there is the opportunity to participate in an AOT program.
Yeah, I think it really all this is really kind of new, right? Now, as I've kind of expressed already, this is really, I think, the next frontier on how we're going to make AOT programs even better than they are. So it's not like we have real established protocols. If there are programs that are doing this now in a kind of robust way, I'm not aware of them yet, but I would love to be. So I really encourage people to get in touch with me and let me know how you're answering these questions about how exactly the process works from one step to the next. But, I think if you have those kinds of protocols in place where nobody's making these decisions independently, it's all being done with full collaboration and communication, then it all sort of happens one step at a time. It's not like, the sheriff who's running the jail is going to be suddenly be informed, oh, by the way, this person you have in your custody has just been placed under AOT. The law enforcement partners and the prosecuting agency all really should be part of the making of those decisions. And so, the handoff should really happen quite naturally because it's a kind of concerted effort by the whole system working in concert to, place this person from one system to another. And, there'll be kind of a sequence of the steps by which that happens because everybody's, part of it.
Yeah, I wanted to add something to that. There are some communities that we've worked with who the behavioral health provider, who also is the AOT provider, actually have people assigned to the jail. That's where their office is, if you will. So in those communities where someone who is truly a liaison between behavioral health and the jail has a regular appearance and a regular relationship with the people in the jail, I think that makes that handoff smoother. It makes it a consistent handoff and one that takes place in a relatively quick period of time. And there are communities that do have those behavioral health representatives that just work at the jail. So I think in that case that handoff can be quite effective and quite quick.
Yeah, that's a great point.
And so we have another question about just asking, what if we're talking about first and second degree charges? So what advice would you provide communities in navigating this when you're dealing with someone who would be eligible for AOT but also has a very serious charge?
Yeah, that certainly makes it harder. Especially when you're doing it in the way I suggest, where you're dismissing charges. I certainly would not blame a prosecuting agency to be even more reluctant to hand away that leverage in a case where there's some, serious violence that's been committed. I think probably that's not where we're likely to find most of the real kind of good cases for this this alternative to prosecution. I think we should probably focus our efforts on finding those folks who have committed low-level offenses, nonviolent offenses, who nobody is really worried about so long as they receive treatment. The stakes get much higher, and it just gets much harder to make that decision when you're talking about someone who's committed a violent offense, who probably is not even going to, in most places, qualify for mental health court. So to say, this person's offense is so serious they can't get mental health court, but let's, do AOT instead where the charges are going to get dismissed, boy, I think that's a tall order. Lisa may feel differently.
No, I agree with that. I think that's, in some cases, it's just impractical, and that is just the reality of this kind of, any kind of jail diversion, any kind of justice diversion. Some cases just simply aren't going to be palatable or appropriate.
And Lisa, you mentioned the program that has a staff person in the jail. So someone did ask, can you or Brian identify one or more jurisdictions that are currently utilizing AOT as a tool in diversion from the criminal justice system? Also, are you aware of a program that integrates AOT into the discharge process for people leaving jail or prison, so more of that step up from jail or prisons versus a step down from the hospital? Could you share about any jurisdictions that are doing this kind of work?
Yeah, I can know of a couple. Do you want to try that one first, Lisa, if you know of any?
No, I know that the ones that I was thinking of, I'm not sure to what extent they've been successful in making that transition. So I know you're out in the field a lot. So why don't you go ahead?
Sure. So, New York is one state that comes to mind as a place where we've actually put in the statute that people who are receiving forensic services while incarcerated in jail or prison should be considered as part of the routine discharge planning for AOT eligibility upon their release from jail or prison. And my understanding is that that's become a fairly common thing in New York. There may be some people on the call from New York who are frustrated in that they haven't really seen that happening, but my understanding is that that's happening in a lot of places in New York, and that has been kind of internalized as the process for releasing someone from a jail or prison. As far as examples of people using it more in kind of the way we've talked about today as an alternative to prosecuting or letting someone sitting in competency restoration limbo, I know that my friend Oscar Kazin in San Antonio, that's Bexar County, Texas, has reported to me that there are lots of folks who have come into his AOT court at the Bexar County Probate Court kind of informally, not through so much a formal process that's been developed the way we've been talking about today, but there have certainly been individual examples where, he's gotten calls from a judge or a prosecutor about someone who, they really would love to find a better way to deal with, and he said, by all means, send him my way, and that's worked out pretty well. So, this is stuff that happens.
Yeah, and I think, too, that as those relationships with CIT and other, the sheriff, as they become more and more familiar with and develop trust and an understanding of AOT, they can become among the biggest advocates for using AOT not just as a step down from hospitalization, but as an alternative to any kind of hospitalization.
All right, and I think we've gone through many of the questions that relate specifically to the criminal justice overlap with AOT, so I'll move into some of the other questions. We've got numerous questions across the spectrum in terms of how to implement AOT. So one person said, in my community, AOT seems to only be initiated upon release from the hospital. How have you started to make it more common to initiate AOT for individuals who are not first identified through hospitalization?
I think that's exactly what I was speaking to before, that a behavioral health professional who maybe their case manager, another provider, or the CIT officers who see someone who may be heading in a direction that historically has led to hospitalization, I guess educating and making them aware that there may be an alternative to intercept that trajectory is a matter of time and education, and they're trusting that if they have somewhere to hand someone off that will provide treatment and get them engaged in treatment, they're willing to do that. There's no magic formula on that. It really takes time for the people who are their boots on the ground in the community understand that AOT doesn't just have to be something that's initiated at the hospital, but that it can, in most cases, in most states, can be initiated from the community.
Yeah, and I think there's actually a really important role for NAMI affiliates to play in this. I'm sure we have many folks involved with NAMI who are listening on this call, and it's not it's surprising that the system itself would most typically petition for AOT at the point where they're about to discharge someone from the hospital because the person's been there 6 times in the last 2 years and they're hoping not to see them again. The system is not really going to have the person on their radar until they show up in a crisis. But families are in a position to see when those crises are starting to develop. They're a couple of steps ahead, and they often are in a situation where they see their loved one is not engaging with treatment, and they are very frustrated in realizing the cycle is going to repeat. It's just a matter of time. And that's really a great point at which, under most state laws, we can actually do AOT straight from the community. But we really need the family members to kind of put those cases on the radar. So, there are states when family members have the authority to actually petition the court directly for AOT. I think that's probably something most would be loath to do if they could get the system to bring that petition, but that requires a situation where the family actually reports to their local mental health authority. My son or daughter is in this situation. They are very likely to become in need of hospitalization in a couple of weeks, but maybe we can short circuit that by getting them under AOT now. Can you help me? Can you bring a petition? And I think NAMI can be very helpful, local NAMI chapters, in working with their local mental health authorities to get the word out that this is a possibility and kind of develop those lines of communication and an understanding among mental health authorities that these are kind of calls should get responded to appropriately, because there are really tremendous opportunities to prevent the kind of tragedy that AOT is typically used in response to.
Something, if I could add to that also, Melissa, just for a second, because I see it also in some of the threads of the questions, other questions that are being asked that speaks to this. The prevention piece is really important, and if for a number of reasons, but also if someone is receiving benefits, like if they're receiving SSDI or SSI or Medicaid, preventing their being incarcerated for an extended period of time will keep their benefits going. If they're in jail for more than 30 days, then we know that can end to termination of benefits, and they have to reapply again. So many people who are on AOT or eligible for AOT are also eligible for a slew of benefits from the county and the state in terms of treatment. And if you're in a Medicaid-eligible state or Medicaid expansion state, many of the people who you will see as being eligible for AOT would also be eligible for benefits that maybe thus far no one has really had a case manager long enough to work with him or her to get those benefits secured. So there's also, and repeated incarceration even for 2 days interrupts the continuity of care, whether it's termination benefits won't happen in 2 days, but it does interrupt the treatment and the continuity of care that a person may be receiving in the community. So there's a lot of reasons to maintain someone to the greatest extent possible in the community rather than this be just a step down from jail or a step down from hospital, but to really make a person's treatment and quality of life a priority and not just waiting until a situation blows up.
And across the country, we're seeing many communities struggle with the opioid epidemic, many communities continuing to struggle with the meth epidemic in their areas. So for individuals who are dually diagnosed with a serious mental illness and a substance use disorder, can AOT include treatment for substance use disorders?
So the answer to that is yes. An AOT treatment plan is going to cover basically the entire array of services that an individual needs to survive safely in the community. And there are certainly many people under AOT who who part of their treatment plan includes that you're going to take part in substance abuse services and refrain from using certain substances that have proven to be bad for the person. One note of caution I would add to that, and I also want to make very clear that I'm speaking really anecdotally from things I have been told many times, rather than with any kind of data to back me up on this. But my strong sense from the programs I've observed is that an AOT order is probably not going to be as effective for someone whose primary issue is substance abuse, right? People who are dually diagnosed exist across a very wide range, and there is great disparity in terms of which issue is the predominant one. And so while I think there are many people whose predominant problem is that they have an untreated severe mental illness, but also have some substance abuse issues that go along with that as they have worked to self-medicate, I think that there is enormous value in using AOT to address both problems. But for someone who has a very serious addiction to a very addictive drug, I think it's probably unrealistic to expect the fact that a judge who has told the person to not take part in that, stay away from that drug, to think that that's going to be very powerful. Substance abuse requires, I think, a really different set of responses, and I think is unlike mental illness in that there really has to be a serious desire on the person's part, a serious resolve to refrain from those addictive substances. And when you think about the things people do to feed addictions, the idea of not wanting to let the judge down, it's probably not realistic to think that that's going to loom large in a person's decision making on that. So I absolutely believe that AOT has its place for dealing with dual diagnosis, probably not so much on the range of that spectrum where the substance abuse issue is the predominant problem.
Lisa?
No, I think that Brian covered that well.
Okay. We've had a couple of questions more, shifting more to talk about incompetency. And so one person asked, when competency is raised, do you have any suggestions on how to speed up the judicial process? I think this person said, I came from the county jail, and some of our competency guys would be held for a very long time.
Yeah. Well, I mean, that's why I really think the way this can work best is if there is buy-in from your DA and an agreement between the DA and the mental health system that in cases where it really seems unlikely that we're going to restore competency and, the charges are not so serious that we really worry very much about what this person would do in the community if they were in a treatment program, I think that if you have that understanding up front where everybody is on board with trying this new approach, then there should be no reason why the prosecuting agency shouldn't come very quickly to a decision to dismiss charges with this handoff to the program. So we don't have to have this inevitable wait for competency that no one expects to be restored in time. We can get in front of that by reaching this consensus.
Yeah, I also think just thinking about, again, the sequential intercept model, and what Brian said is, in the case of competency, it is the prosecutor and, to some equal extent, the defense attorney who's willing to agree to not go forward with a competency recommendation. I think that at each one of those intercepts, there are certain key players who either can facilitate or hamper the implementation of AOT. And I think if you're thinking about all of those different critical points, and I know competency to stand trial is a huge issue in every state, and that there's a lot of people who are on wait lists for forensic beds and are sitting in jail, that this might be one of the ways to relieve some of that backlog, and to do it in a preventative way, but it's going to require that the prosecutor and to a large extent the defender and the judges are on board with that as well. Sometimes the criminal judges think that what goes on the civil side is just none of their business, and it's a matter of education and getting them to understand that, in fact, someone being put in jail and then waiting for a state hospital bed might be out of sight, but they certainly shouldn't be out of mind, and there may be an alternative that would get them into treatment faster.
All right, so I'm just going to do one more question, and then we'll move on to wrapping up this presentation. This is more general, and I think that you've also started to touch on this a little bit, but I think it's a concern that many communities continue to have. One of our listeners said that she was told by a representative for VERA's pretrial justice program in New Orleans, who implemented law enforcement assisted diversion, that they would not support AOT because it's coercive. And so what are your responses and thoughts to that kind of concern?
Well, one thing I'm delighted to report is that New Orleans Parish has an AOT program now. It launched, I think, just a few weeks ago, just before the new year. So, I think the person who may have expressed that opinion will hopefully see a different reality in what they're accomplishing there. But, I just don't think of AOT in those terms at all. And I don't think anybody who's really sat down and sat through a series of AOT hearings would have that feeling either. These are programs for people who have suffered enormously as a result of their difficulty engaging with treatment, who have been through, been to hell and back multiple times. And, this is a program that throws them a lifeline. Now, does it sometimes have to override the fact that a person lacks insight into their illness and can't see that they have a severe need? Yeah, it does that, but not in an arm-twisting, scary, coercive way. It does that in a very loving way, and hopefully, for a short time as possible. And, what I have seen again and again is that, even the minority of people who enter these programs, unhappy about it and resentful and feeling like they're being forced to do something they don't want to do, the reason this works, AOT is not something that is kept in place forever. It's generally done for a year or so, and it doesn't work with everybody by any means. I mean, there certainly are the results are not universal, but the reason the data tells us this is helping with lots of people more than anything else we have to deal with this very challenging population is that folks come to see that their lives are better, even if that insight doesn't come back where they realize they have an illness. They develop habits of treatment compliance, and that hell they had been living through fades away, and they start to realize that they can actually achieve the things they wanted for their lives. And that's a hard thing to argue with, and it's hard for me to think of this program as being coercive when I see the people who receive it in such overwhelming numbers being really glad that it came into their lives. And you can look at the data we have from New York, interviewing the people who've been through AOT to really see that come through.
Lisa, would you like to make a closing comment?
I think that it's. I understand the origin of that concern, and I think that there are certainly circumstances where AOT perhaps hasn't been implemented either on an individual level or community level in a way that would suggest that it's not coercive. But I also think that it's one of the hallmarks of a good AOT program, and Brian mentioned this before, but I think it's important to keep in mind, is that it also commits the provider to the individual, because sometimes treatment programs are client resistant rather than the client being treatment resistant. And AOT binds them both to this court order. And just as someone could be brought before the judge, the committing judge, for failure to comply with treatment, the provider can also be brought before the judge for failure to make every effort at trying to provide services that are both helpful and evidence-based. So the good programs, the responsibility goes both ways. And so I think in that regard, it perhaps might be viewed as a little less coercive. It's really a mutual pact in terms of determining what is the best, is in the best interest, and the person having input into, they are individually focused case plans is the intention under AOT, that the individual has input into their case plan. So I think with that in mind, it takes some of the sting away from the concerns of it being coercive.
Thank you. All right, so we'll move to the next slide. Many of you, just briefly, here is a quick link if you would like to sign up for our listserv. If you do want to get slides and the recording of this once it's published, please sign up for this newsletter. I also want to mention that we did hold a previous webinar called 7 Habits of Highly Effective AOT Judges, and that was held last year. And many of you had questions about the judge's role in AOT and how that interaction should look like. So I encourage you to check out that webinar. That YouTube shows the entire recording and the presentations by the judges involved with that webinar. That could be a resource to you. And also, going to the next slide, any of you who continue to have questions about implementing AOT, do not hesitate to reach out to us here at the Gaines Center for Behavioral Health and Justice Transformation. You see our website there. You can enter in a query or a message to us through the website or call us through that phone line. And we are available to provide phone-based TA to any community that reaches out to us. That's one of the tasks that we're funded to do for you all. So please take advantage of that resource. If you continue to have questions about AOT, do not hesitate to reach out to us directly. We are coming to the end of this webinar. Thank you so much, Brian and Lisa, for your time.
My pleasure. Thanks, everyone, for listening.
All right, and with that, we look forward to seeing you next month. And our webinar next month will be covering innovations in crisis response models. All right, thank you so much. Have a good evening.
You too.